the stage. One is Amar Aldak, principal at Amar Aldak IP Law Firm, UAE, G. Deepak Srinivas, partner Rajeshwari and associate from India. I welcome him on the stage. Thank you.
Thank you. Hi everyone, good morning. I didn't say anything yet, so that's good, thanks. So good morning everyone. My name is Amar Aldak. I'm a US patent agent based in Dubai since 2018. And it has been fantastic 5 years, and we'll talk today about patent laws and strategies. But before that, I would like to introduce my fellow panelists.
Hi, good morning. My name is Deepak Srinivas. I am from India, from a law firm called Rajeshwari Associate. Primarily, we deal with litigation, and apart from that, in the last couple of rather 4 or 5 years, we have expanded our practice in drafting, prosecution, and parts. And when we talk about patent strategies, coming from the litigation perspective, evolving the strategy from search, drafting, and everything has to be taken into consideration from the litigation perspective. Because it's not just simply getting a grant, which is having a paper tiger. After all, it has to be enforceable. So that's what we are focused upon. And with that, let's start the session.
As you can tell, we don't have a real prep, so feel free to interrupt us anytime, asking questions. Let's make it a more interactive session, more than we just talk and you guys wait till the end. So basically, when I thought about the title Patent Law and Strategies, I'm sure everybody in this room knows and they are very capable to come and sit here and talk about the same topic. So I thought it would be much better if I can talk about it from a regional point of view. So how the patent laws in the last few years in the Middle East have changed, and how that could be reflected on patent strategies for IP lawyers and counsels. And as my fellow Deepak said, he will take it from the litigation point of view, which is even complementing what I will say.
Also, I'll give you a heads up on some of the recent changes which are expected of. Because India, we had roughly 6 months back, we had draft rules which was formulated and which the public had the opportunity to make comments on it. And if it comes into picture, what will be its real implications? So probably you can keep that in mind, because that will have a huge and long-term effect in terms of the way that the patents are being enforced and prosecuted.
So in the last few years, actually a lot of things in the IP ecosystem has happened in the Middle East. Many countries, including the UAE, has changed their laws. They actually have changed the structure of the patent and trademark offices. For instance, in Saudi Arabia, they have already united all the IP departments in just one agency, Saudi Arabia IP Authority. In the UAE, they actually have also made some structural reform to the patent and the trademark departments, and changes in the Ministry of Economy. All of this, and also in Egypt, they also have made a new IP strategy, which will also unite all the IP departments in one agency, similar to Saudi Arabia. This is still undergoing. So a lot of changes in the Middle East has been going, reflected also on many conferences like this. It used to be when I came 5 years back, not as many as the ones we are witnessing right now. And all these changes in the agencies has been also reflected on the laws. Like 3 years back, the UAE has the year of legal informant, or 50th year, where over 40 laws has been amended and changed, and new laws came out. For the IP, we have a new patent law in 2021 and implemented regulations, which has a lot of changes that we will talk about that make things in more harmony with global IP practices. And at the same time, this has been also open doors for investors to come, and for inventors also to come and protect their IP here without having the issue of what's this legal ecosystem here is working, how it's working, can we compatible with them or not. So a lot of changes and laws. The first thing I would say that really was crucial in law changes is the grace period. The law now, it used to be we have here absolute novelty, which means that if you presented in a public domain your invention, then you are done. You can't really file or protect it anymore. So this was really tying for academic institutions, for companies to really present and have their inventions out. Right now in the UE here, you have 12 months as a grace period, which is really very helpful. And this is, as I said, make things in harmony with the global IP practices. Another thing is publication. It used to be, and actually till now, it's kind of black box to know in the UE who filed what. You really don't know much. You don't have information. And even if the patent has been granted, you really don't know much except maybe the abstract and a little bit about the bibliographic information, which is a little bit hard for FTOs if you want to know if somebody is infringing or invalidation. All of this is really hard to practice. But the new law brought the publication element to it, which is going hand in hand with the international IP practices, that after 18 months from filing of the priority, you will have everything. You can see the file wrapper on the patent office website. They promised that this is going to start in February, so we are very close to witness that, and that will be huge for transparency. Also, I forgot. So, accelerated examination. This is one of the things that we really were asking for, because it's really a problem for infringement. If it takes here from 3 to 5 years just to get your patent application granted, then if some infringers are out there in the market, you have your hands tied, cease and desist letter, and that's it. You really can't do much about this, but right now, it's already in practice that you can ask for accelerated examination. Within 6 months, you will have your patent application examined, and you will have an office action or examination report, and that's for a fee. The same thing has been happening in Saudi Arabia for quite some time right now, and even Saudi Arabia, I think, has a step forward, because right now they have the BPH, which is really fantastic if you have multiple jurisdictions, one of the big offices, so you can just, if you got granted in the US by one track, and then in Saudi Arabia you can just go to the BPH and you get your application granted also. All this is actually post-grant proceedings. Right now in the UE, they are actually having more transparency through publication, and at the same time, they made a new procedure that you can apply for post-grant examination for a patent application. So this is really also helpful for invalidation, and if you want to have an application for a competitor or something, you can also qualify for this. All this is really going to affect your patent strategies and how you can do business here. And as I said, they are trying to harmonize all the procedures with the international scene. And at the same time, they try to clear the backlog. It used to be 2 years ago, it's about 4 to 5 years. Now it's about 3 years or less. So hopefully by middle of next year, it will be about 6 months, I believe. They mentioned that. So things have been moving very fast in the UAE, Saudi Arabia. Egypt is trying to catch up, but still a lot of things is happening, but not at the same pace. So,
a lot of
in terms of the Indian patent law, I feel it has been more or less in line with the global laws for the last 18 years. 2005 was the last amendment which was made, and also the changes were made at that time in terms of introducing the product patent regime for all pharma and agrotech and all chemical, and that brought the Indian IP law at par with the TRIPS requirement. Thereafter, there have been some changes in terms of the rules part of it, and there have been a lot of other upgradations which have happened at the IP offices. He talked about the publication, the IP system in India, especially the patents have been publishing all the applications post 18 months for the last 20 years, 2005 onwards, all the applications have been published. And you can get the complete file wrappers of all the patent applications online. You do not have to probably even engage a counsel in India to do the searches. The IP systems are freely available. India is peculiar in terms of the opposition proceedings, especially because what we have is a pre-grant opposition phase and a post-grant opposition phase, and thereafterwards we also have a revocation phase. Pre-grant opposition phase starts from the date of publication until the time the patent is not granted. So which means 18 months onwards, or if you are requesting for an early publication, from the date the application gets published, you have a right, a public has a right, and public it means anybody, it's not just interested party. Public has got a wider definition in the pre-grant opposition stages, whereas in the post-grant opposition stage, it has to be an interested party. So somebody who has a direct interest, somebody whose interest in the sense of commercial interest being hindered may be considered as a party interested. Whereas in a pre-grant opposition, it can be anybody, any remote person also, but having to do some amount of research activity, let's say, for example, he can file an opposition. And the opposition period till now is an open-ended period from the time the publication happens until the time the patent is not granted. It becomes really a very huge time period, and which particular aspect has been misused by most of the opponents in the India because of sequential filing of oppositions. I don't know whether you have prosecuted, especially the opposition parts of it, anybody has. But what generally happens in India is that, let's say that here is a patent application which is of commercial interest, and there are a huge number of parties who are into the market and putting up the product or considering to put up the product. They will have the opposition sequentially, one after the other, one after the other. So by the time the first opposition gets dealt, the hearing is being conducted. The first opponent will know all the arguments which the applicant is presenting. He will go back, and then there comes the second opponent who will try to plug in the gaps between them. So then the second opponent will be heard till the time the first opposition is not disposed of. There is no order being passed. So by the time the opposition proceeding is on the date of the hearing or just before the date of the hearing or 1 or 2 days after the first hearing is conducted, the second opposition comes into picture. And then comes the third opposition, fourth opposition. So it becomes a huge challenge for especially the patentee or the applicant to handle oppositions of this nature. One of the things which the high courts have done to deal with it is to instruct the patent office to see the similarity between the documents and the grounds taken in terms of the opposition proceedings. If there is a substantial overlap in terms of the grounds, or if there is a substantial overlap in terms of the documents, the courts have said that the controller need not send the opposition proceeding, need not entertain the opposition proceeding at all. That is, he may say that please come, the opponent, instead of serving the notice onto the applicant, he may just simply call upon the opponent to say that, okay, while you filed the opposition, I don't see a substantial merit in this. So please convince me about, sending these documents to the patentee. That's something very unique especially in terms of cases, we have been doing it from the applicant side as well as from the opponent side. And both the times it's a very huge challenge. Then it comes as to the stages of the opposition. If you look at any opposition, in India the opposition would be that you file the document, and many a time you would want to rely upon technical affidavits, expert affidavits to take some particular strategy that, okay, here is the inventive step, how the inventive step has to be taken, why the documents can be combined, how it should be combined, why this particular feature becomes obvious. So you would want a technical expert to come on the board and talk about it. Generally what we would see is in the pre-grant opposition procedures, the technical affidavits are not filed at the time of filing of the opposition. You will wait for the patentee to reply or the applicant to reply, then as a delay tactic. Because if the hearing is scheduled and if you are filing the affidavits, probably let's say 15 days before the actual hearing is going to take place, it becomes a huge challenge for the applicant to deal with the technical affidavit. So, lot of delay tactics happens in terms of the opposition, especially the pre-grant opposition procedures in India. One way to address it is to file a request for expedited examination. Now, to take up the request for expedited examination, there are only two options which are available. If it is a national phase PCT application, you should have designated India as an international searching authority. If you have designated India as an international searching authority, then you are eligible to file a request for expedited examination, which means that then the patent office is guaranteeing that within a limited amount of time period, within an upper bound time period, they will issue an examination report. And within a certain amount of time period from the filing of the response, they will dispose of the case. So whenever you feel that there are some cases, very selective cases, I'm not talking about cases which are, like all the cases, but there could be selective cases where your client feels that India is a huge potential market for it. In those cases, the option would be to take Indian Patent Office as an additional searching authority. You do not have to delegate because PCT allows you to choose multiple searching authorities. You don't have to select only one. You have to select one, that's a bare minimum, but you do not have to be restricted to one, you can choose two. And when you choose two, the cost of choosing Indian Patent Office as a searching authority is almost $200, nothing more than that. A very bare minimum fee, $100 to $200, probably $180, less than that, depending upon the dollar fluctuation rate, but nothing more than $200. And when you do that in the PCT application, you are opening up your right to file a request for expedited examination in India. Many a time, the international filers are not aware of this particular provision and they do not ever select it on. And they believe that, okay, fine, I will have to go and stand in the normal queue, which has got a waiting period of, let's say, 3.5 years to 4 years. While the queue waiting period is diminishing, it used to be 7 years and 10 years at some point of time. Now it has come down, it is still 3 years. Still coming down, but if you are filing a request for expedited examination, it could be less than 6 months. At that point of time, the opportunity that the opponent will have to identify the case, because what generally happens is the technology has been tested out, and by the time, 5 years down the line, there is a huge amount of competition created. But when we are looking at it at, let's say, 1.5 years down the line, where the technology is very nascent, there may not be huge amount of competitors willing to invest in the technology. An early bird will not be there. So when you are getting the patent in hand at a very early stage, you are aware of the worth of it, your client knows that India is a good target market for it, your internal team, your client has got a fully developed prototype or a fully developed product out of it, the competitor has not got it. So that is the time advantage. When this is the case, you might recommend to your client to file an international searching authority, choose Indian Patent Office as an additional international searching authority. Come to India, not wait for 31 months. You can come to India even after the date of filing of the PCT application, 1 day after the date of filing of the PCT application. I would say that just wait for 18 months, get the international search report from the Indian Patent Office, come to India, file the request for expedited examination. In about 31 months, that is from the date of priority, by the time generally you enter into India, your entire patent could be granted, which gives you a huge advantage. By the time the competitor may not be aware of it. And if the competitor is not aware, you can avoid this entire pre-grant opposition challenges, sequential challenges. And generally, each pre-grant opposition costing or handling a pre-grant opposition challenge would run into at least few thousands of dollars. Here, what your expenditure is, couple of $100 as excess fee for designating Indian Patent Office as an additional international searching authority. Then a request for expedited examination. So there is an additional fee as compared to normal. These are the only two fees. And the overall of put together these two, the overall expenditure, additional expenditure could be $500 to $600. So for a very marginal price, you get to prosecute at a very faster rate cases of primary importance to the client, especially in India, and avoid the entire pre-grant opposition proceeding. That's very, very attractive for some of them. And we have seen, especially in some selective cases, the applicant choosing it. For example, there is a huge telecom giant who files a good number of 5G applications in India. At some point of time, they used to be filing the first application in Europe. Now they have shifted to filing the first application because Europe does not have a foreign filing restriction. So they choose to file the first application in India and identify probably if there are some Indian inventors and one of them is a lady, they use that too, because if there is a lady inventor available, lady applicant available, they can use and file a request for expedited examination. So they use multiple options for early prosecution of the application because of the simple fundamental reason that if it is of very important case and if the competition is aware of it, they will try to delay the grant. Until the time the patent is not granted, you have no enforceable rights. You can at the max send only cease and desist letter, as my colleague said. That's all. But that will just, you send a cease and desist letter, in fact it will start the chain of pre-grant oppositions. There was one particular case which I remember pertaining to glass, coated glasses, tinted glasses, where there were 530 oppositions filed against one single application. The entire glass industry, 530 oppositions were filed. And if you take the 530, you can just simply see that they are all just photocopy of each other. But the controller was forced because at that point of time, he was not pretty clear how to deal with it. All the parties were interested parties. It was not uninterested parties. All of them were small manufacturers of glass. So all of them were interested parties, but he didn't know how to deal with it. Likewise, when we look at the pre-grant opposition stages, you will avoid this entire major chunk of it. Coming to the next one, what was the next topic that you touched upon? Yeah.
So many. Not now.
Not.
Okay. So if you have any questions,
Yeah.
let us
I
know.
just have one comment on the last point you said about 500 plus opposition against one application. In some other countries, when they see this situation happen, like filing opposition for no reason, they increase the official fees to file the opposition. So some people will, if they are not really interested in the patent, they will not file the opposition.
To give you the answer to that, till now, a pre-grant opposition can be filed without paying any fee. No fees.
For free.
Free.
Oh.
So what is the actual expenses is only the search and the lawyer fee. Official fee is 0. Now they have put forth a recommendation and which was formulated in the form of rules which said that in case there is an opposition, the opponent has to file the same amount of fee as to what has been spent by the applicant till date. So in case you are filing an opposition and the applicant has spent, let's say, 40,000 rupees, the opponent, while challenging the application, will have to spend 40,000 rupees. If on the other hand, the applicant has spent, let's say, 90,000 rupees, the opponent has to remit 90,000 rupees. So you cannot file the opposition, and it is not a fixed cost. The cost is depending upon what is the amount which was spent by the applicant. That was what was proposed in one of the recent rules.
Is it just a recommendation or it's approved already?
It was a rule, a draft rule, which was put up for the industry to comment upon. The comments have been received. The rules may come up in the amended form or may come up in the same form. We do not yet know. And also we are not exactly aware as to the date when it will come. But the rules, draft rules were published for comments probably 6 months back.
Yeah, probably 6 months back.
Yeah. So confirmed by my colleague Piyush. So he said that yes, 6 months, it took about 6 months back, the rules came. And this was one of the huge changes because
From your point of view, this will help?
yes, this will at least help in terms of reducing the number of frivolous oppositions which come into picture. See, that's one side of the table. But if I have to look at it from a neutral perspective, fine, I agree that, let's say my dear friend here is interested in opposing one application. I'm interested in opposing the same application. Both of us are actually competitors in the market, right? Just because he has opposed does not or should not take away my right to oppose, because my interest and the patent is being held by, let's say, by you. Both of us are internally competitors and we are also competing against you. So my right should not be taken away. So they can't curtail the number of oppositions being filed. But what they are trying to do, and neither they have been able to come up with the aspect of curtailing the time period, because it is a pre-grant opposition. So prior to the grant, it can be filed. The courts have been pretty clear about it, that prior to the grant, and if the grant is getting delayed, it's not the opponent's mistake or it's not the opponent's chances. It's just getting delayed. There are many times the delay is happening because of the applicant also. I'll give you one instance. For example, if you look at India, the request for examination can be filed up to 48 months from the date of priority. You can file the application and assume that you have filed a first application in India. 18 months down the line, the application gets published. But the applicant has not filed a request for examination. He files it at the 48 months. The entire 48 month is delay is not attributable either to the patent office or to the opponent. It's only attributable to the applicant himself. He did not take the bus error. He could have just filed the request for examination at the time of filing the application. But he didn't do that. So the time delay is not sincerely or solely attributable to the opponent. There are multiple factors. We have seen many instances where the examination report is issued. General tendency, the applicant files a reply to the examination report 10 days before the deadline. The applicant gets 6 months period to file a response, but he files the response 5 months and 20 days, 5 months and 25 days. So he is sleeping on that. He could have filed the response, let's say, 2 days afterward. Many times the examination reports are inspired examination reports. You would see the objections very similar, the citations either from US or from EU. So aligning the application with that could be much easier. So at the end, to only act as a hindrance, this is as a proposed rule, but is yet to take implementation.
One more comment regarding from your experience in India, regarding the number of filing the patents. In UAE, for example, most of the applications are PCT applications filed as a national stage in UAE, but the number of local filing are very less. So what is the situation in India? I mean about the filing of the patent itself, local and PCT application.
See, from probably 1970s to 2015 to 2017, the ratio was 80s to 20. Foreign applicants 80%, local applicants 20%. And from 2017-18, the ratios are changing. Now the ratio is probably 60% foreign applicants, 40% domestic applicants. And that's primarily because there is a huge amount of motivation and incentives which are provided, especially to local players. If you are, let's say, an educational institute, you are treated at par in terms of the filing cost at par with an individual. So you do not have to pay the fee, which is generally for a large entity. You are ready to pay the fee for a small entity, and you can also do a fast examination. So all of them are contributing to increasing the number of applications being filed by domestic players. But that's only in terms of filing. We are not talking in terms of grant. The grant ratio is still probably 80:20 only, because these filings are being done for some other commercial purposes. They have various other incentive schemes. They are not purely IP-driven cases. So many of them would say, fine, I have a patent application filed, my institute gets a good name, I can have some government funding coming in, that's all. They are not too much worried about the grant part. So in terms of grant percentages, it's still 80:20.
Can the two entities jointly file an opposition if they have a common interest in the opposition?
Sorry, sir, I can.
If the two entities have common interest in as a basis of opposition, so can they jointly file the opposition?
Sir, the issue would be that each entity will have to file it on its own part. Okay. There is no provision which allows joint entities joining together and filing a single opposition. And many times, forget about entities filing a joint opposition. If even when we are looking at a litigation, a single patentee is litigating against 7 defendants, their defenses are not consistent. So many a time the defendant themselves will not want to be on the same cart. There may be marginal differences in terms of their argument strategies, the way they want to interpret a particular document. And the law also does not force them. Neither it gives an enabling provision, nor it forces them to join hands and file a single opposition. When they are looking at opposition coming, 4 different opponents wanting to oppose, they can file it separately, and each of them can have the right to argue differently. In one of the recent cases which I was present as a defendant part of it, or as an opponent, there were 7 opponents, all of them were interested parties, and it was very surprising to see as to the nature of interpretations being taken by each counsel in relation to certain paragraphs of the same specification. One document was consistently the primary document. All 7 of them had single document as a primary document, and the issue was some of them took that primary document for novelty purposes, some of them took it for inventive purposes. Now, if I am an opponent who wants to take it for novelty purposes, if I onboard the card which says that I will take it for inventive purpose, I am losing one of my primary grounds. So I do not want to onboard the card at all. So in most of the opposition, I have not seen parties coming together and filing a single opposition. On the other hand, what I have also seen is industry unions participating and filing oppositions. We have, let's say, agrochemical, pesticide industry, manufacturers association, which is actively involved in filing oppositions. Once the opposition filed by them is dealt with, it does not debar the individual members of the association to also file the opposition. After all, the members association is just simply a custodian of some common interest. So the parties, when the claims are getting restricted during the opposition proceeding, some of them may still be interested. The member association may not be any more interested. So member association sees that, okay, the wider scope is no more being chased. So it may withdraw the opposition, it may not prosecute or proceed forward with the opposition, but some of the members may be still interested. So they may want to chase it. So all these scenarios are happening. We have seen all of them. In especially in pharma, there is a patent which is being enforced, a series of patents which are there, pertaining to a combination of two active molecules. And initially it was admixture, then there was a complex, then a specific type of polymorphic forms of the complex. So when we look at this entire chunk of applications and look at the defendants, some of them are making only admixtures. So they are worried about admixture patents, they are not worried about complex patents. So they don't go and chase the complex patents. So the defendant industry, or rather the infringing industry, is not consistent in terms of its products. They are not ditto identical to each other. There are variations in all of them. Some cases we had a hydrated form, 2.5 hydrated form. So some of them had 3.5, some of them had 7.5, some of them had 2.5. Initially when it said, the claim said hydrated, all of them were getting affected. Subsequently when it said 2.5 hydrated, only the 2.5 hydrated industry was getting affected. Remaining parties withdrew the oppositions and they were happy with it. So it all depends upon the individual players also.
So from your job as IP attorney, what will be the requirements you are asked? For example, Mr. Amr filed a patent application in India, and I come to you, I want to oppose his application. What will be your requirements from me? And are you doing some kind of evaluation? Will be the grounds of the opposition will be accepted, or you are giving the client some kind of evaluation, or will just file the opposition and leave the decision to the patent office?
Sir, 90% of the time we can tell you that what will be the chances of success. Okay, at the time of filing of the opposition itself, we know that what is going to be our chances of success. We will ask you what is your purpose. Okay, what is it that you want out of it? Presently you have a broader set of claims. What do you want out of it? You want the claims to be restricted? We can ensure that the claims will get restricted to some extent or to this extent. We can tell you that, okay, here is a case where you can be safe, you can be sure that we can file the opposition. The documents we will tell you, but we can't tell that without conducting the search. Okay, we will first conduct the search, be clear about us. And we do the searches ourselves. We are not dependent upon the searches by international bodies or client even. We will do the search ourselves. We will come to know that what is the argument strategies, what grounds can be taken. We can tell outrightly that fine, here is a good set of documents, I can ensure that we file the opposition. There is a 50% probability that the applicant will not contest it. And it has happened many times, where we file with good number of very good quality documents. The opposition goes uncontested, the applicant surrenders. It happens even after the applicant files a response to examination report. So it is not our choice. It is after all what you want. And we can tell outrightly to what extent we can succeed out of your expectations. Whether we can knock it off or we can't knock it off, we can only go to decreasing the scope of it, or we can only attain to some extent deletion of some claims, safeguarding your particular business interest. Do not mark it 2.5, go to 2.7, go to 2.8. We will create a prosecution estoppel. Many times, creation of a prosecution estoppel is also primarily important for us. What the oppositions are being filed. We believe that the oppositions are filed for knocking off the patent. My statement is not that. The patent oppositions are also filed to create prosecution estoppel, which you can utilize during the court. You can use certain statements provided by the applicant to say that this is the statement which he provided, look at it, what he has said is not me. So purpose has to be pretty clear. We can tell you the purpose, we can set it out to you that this is what we can take. We can't do, all times we can't go for nothing. But purpose is, many times the purpose can serve you. That's creation of a prosecution estoppel may in turn be sufficient to serve your purpose. There are cases where we were talking about some plant genetic material. Okay, there the issue was the prosecution estoppel acted and came up to such a large extent to say that what is it that the scope of the protection is being afforded is nothing but the plant genomic material itself, because there is no utility of the gene sequence apart from being used as a plant. That was what was taken from the prosecution estoppel, which was more than enough to keep the enforcement out.
So we are out of time, so thank you everyone.
Thank you.
Appreciate it.
Thank you so much. Now I request our panelists to hand over the momentum to each other.